Good morning, my lords and my lady. I appear in this appeal with my learned friend, Ms. Chowdhury, for the revenue, who are, of course, the appellants. My learned friend, Mr. Prosser, appears for the respondent, which is now called Delinean. Right.
Can we call it Euromoney?
Well, I was going to call it Euromoney for a number of reasons. Mainly because that's what's in my head, but also because it's how it's referred to below, and it was its name at the time of the transaction. So yeah, I'm going to refer to it as Euromoney. This is an appeal from the Upper Tribunal, which dismissed the revenues appeal from the first-tier tribunal, which itself had allowed the taxpayer's appeal against the conclusion and amendments made in a closure notice. This relates to the taxpayer's return for the accounting period ended 30th September 2015. Can I just deal with it briefly with housekeeping? There isn't very much in this case because I think, am I assuming that Master of the Rolls and Lady Justice Whipple are working electronically?
Yes.
Entirely.
You can assume
I'm hybrid.
Hybrid, okay.
I'll just choose when I get
okay. Well, if anyone is working on paper, we have one of the cases is not in the paper bundle, although I think it is in the electronic bundle, because it was added in right at the end before.
So we worry about that when we get to it.
Well, yes, it's Brebner, but we can hand it up at that point.
Brebner, yes.
Brebner, yes.
Lovely.
Which I think you'll find at the end of the electronic bundle.
I mean, so Mr. Ewart, would you mind sliding a little bit towards the centre of the court?
Yes.
Hiding in that corner sort of gets you behind my big screen.
So,
that would be marvellous. And I can see your junior as well, which is even better.
Yes.
Thank you very much. Perfect.
So we have two bundles. One is the core bundle, and then there is also a supplemental bundle, but they're very small, and I will be mainly almost entirely looking at the decisions which are in those bundles. And we have a small bundle of authorities.
We've done a lot of reading, Mr. Ewart, and we've done a lot of thinking, so we're ready to proceed with the argument.
Good. So what you'll be aware of then, that this concerns an exchange of shares in Capital Data Limited, which is CDL, for ordinary shares and redeemable preference shares in a company called Diamond Topco Limited, DTL. And you will know that prior to the exchange, CDL was owned by Euromoney. Subject to the application of the reorganisation provisions, which we will look at, the exchange was a disposal by Euromoney of the shares in CDL for the purposes of corporation tax on chargeable gains. And again, subject to the reorganisation provisions, this disposal would have resulted in a tax of 10 million odd. Can I then outline how I intend to structure my submissions? I will be getting to the argument very quickly, my lord, you'll be happy to know. First of all, I'm going to look at what was found by the FTT, and particularly certain aspects of that, which I say are important to the argument that we're going to have. That's in relatively short compass. Then I will take you through the relevant statutory provisions, and at that stage, as is my normal practice, I will at the same time make submissions on the construction of the provisions. I think that's the most convenient way probably to deal with it. And then I will look at a very few authorities which are in the bundle. And finally, I will then look at the FTT decision and make my submissions as to why it was wrong. And then, of course, look at the Upper Tribunal decision and explain why it was wrong not to overturn the first-tier tribunal decision. So, without any more ado, can we look at the first-tier tribunal decision? It begins on page 86 of the bundle. And can I take you to the facts?
If your junior were able to send me, or your solicitors were able to send me Word copies of both the UT and the FTT, I would be grateful. For some reason, I haven't got them. Not urgent.
Yes. So this was a negotiation which is described in paragraphs 14 and 15. And you can see in 14, Euromoney attached great importance to acquiring the maximum equity stake in DL because it thought it was going to grow in value. On the other hand, Carlyle wanted to give as little as possible. And you can see from paragraph 15 that there was a hard negotiation over what the Carlyle was going to give, how much of an equity stake was going to be given and how much cash. And that resulted in the deal, which is in the last sentence, the last two lines of paragraph 15. So that Euromoney disposed of its holdings for $85 million to be satisfied by 15.5% equity plus 26 million in cash. And then what happened was on the 17th.
I think it actually says agreement in principle.
At that stage, yeah. Yes, that was the.
So it's
Sorry, they hadn't finalised the agreement at that stage. But that was the commercial agreement that had been settled, and we will see that. You can see from the other facts that no one wanted to dislodge that commercial deal, and particularly paragraph 45 in the findings of fact. That was a commercial deal, and the question then was what Mr. Flint then said, which we have in paragraph 16. So Mr. Flint was sent an email on the 17th of October, and what the email said was that this was the deal. And it outlined the commercial deal. And his response is quoted in that paragraph, where he sets out what we say is the scheme of arrangements that were proposed to have the effect that there would be no tax paid on the exchange.
Para 45.
Sorry?
Para 45.
Para 16.
Oh, 16.
Para 16, my lord. It quotes what Mr. Flint said in his email.
Yes.
Would it be feasible to issue 26 million of fixed rate preference shares instead of cash? That way all the capital gains rolled over into the ordinaries and the prefs. Once a year has passed, we can redeem and sell the prefs to Carlyle and get SSE as substantial shareholding exemption.
So you say that was the scheme or arrangement?
So that was the scheme that was proposed, and that was the scheme that actually was carried through. We will see from the findings. And then in paragraph 17, you see Mr. Fordham saying the preference shares are the mechanism to avoid paying tax on the capital gain for the cash element of the transaction. In 18 months, we convert the preference shares into cash and avoid paying 20% tax on the gain. And the important point was that the terms of the preference shares were they carried no rights to dividend, no rights to vote. The only rights they gave were to be redeemed. They could be redeemed for cash after a year.
I mean, the scheme or arrangements is simply the redemption of the preference shares in accordance with the terms on which they were issued.
Well, it's also
according to you.
It's also issuing the preference shares as part of the exchange, and then waiting and then redeeming them.
But there's nothing more than the redemption of the preference shares in accordance with the terms on which they were issued.
Exactly. Yes, that's right. At a time when they qualify for exemption. That's right. That's exactly the scheme. And there's no doubt in this case that this was, however you categorise this was planned and not as part of the commercial deal in order to avoid the tax that would have arisen on the commercial deal, which was ordinary shares and cash. If they had simply exchanged for ordinary shares and cash, there would have been a tax charge. And it's that tax charge that they're seeking to avoid.
Mr. Yo, why are we looking at the an intermediate stage of the negotiations to consider the application of the statute? Why don't you actually go to the end of the negotiation and look at the transaction that was actually agreed to decide whether it falls within Section 137? As a matter of timing, it seems most sensible. I mean, if you were to look at any negotiation, things would be discussed for tax reasons and for commercial reasons and for all sorts of other reasons, and it makes it rather difficult to apply the statute, doesn't it, if you salami slice it and have to look at each stage to apply the test?
Well, with respect, my lord, we're not looking at each stage. We're seeing if we can identify a scheme or arrangement which has a main purpose of avoiding tax. And as we shall see in a moment, the tribunal decided that there was a scheme or arrangement in those terms which did have a main purpose of avoiding tax. So I can just turn you forward to paragraph 77. After in paragraph 76, the tribunal quite rightly adopts what was said in Snell by the Chancellor. And then the tribunal says in 77, both descriptions of the arrangement, and those are the descriptions, that you see in paragraph 73 above and 74. So paragraph 73 is the revenues proposed, what they say are arrangements, and paragraph 74 is what the taxpayer says are arrangements. And what the tribunal then says is that both descriptions of the arrangements offered by the parties amount to a combination of things for a purpose. That does not settle the question of whether the arrangement should be taken as a whole or the arrangement should be considered in relation to the preference shares only. And then if you turn forward to what they decided, if you look at paragraphs 92, 93 and 94, you will see that what the tribunal decided was that there were two sets of arrangements that could be identified. And this is quite important, my lord. Our submission is that in any transaction like this, it's possible always to identify a number of different sets of arrangements. You can say this is a set of arrangements, there's another set of arrangements. There isn't just one set of arrangements. What the tribunal did in paragraphs 92, 93, 94 is say, we think that the appropriate or whatever set of arrangements are the arrangements put forward by the taxpayer. And then they went on to consider whether there was a main purpose of tax avoidance in those.
Well,
but they then went on in paragraph 94 to say, if we're wrong about that, if they are the arrangements of the taxpayer, so the revenue put forward, then we hold that there was a main purpose of tax avoidance. In fact, that was the only purpose in those arrangements. And it's our submission when we look at section 137, that what you have to do is look and see whether there are arrangements which have a main purpose of avoiding tax and of which the exchange forms a part. And if there are such arrangements, then you fail 137. And it's not a question, we say it's a very important point, it's not a question of the tribunal deciding as a matter of fact which arrangements it likes better or which it thinks are more appropriate arrangements to apply the test to.
So what I've written down is that 137 requires you to ask whether there were arrangements that had a main purpose of avoiding tax, not, just say what you said again.
Also of which the exchange formed part. It's important as part of the definition.
Of which the exchange formed part, not
what are the most appropriate arrangements. As a matter of fact, in some way, in matter of fact.
What the tribunal was doing there was, as I understand it, was contrasting your view that arrangements on the facts of this case was quite a narrow concept because it was essentially the exchange of it was the preference shares and their subsequent redemption against Euromoney's wider view that it was everything that had gone on, and that what they then decided they preferred the Euromoney wide view. But you say, I think, that that's I'm just looking at section 137, you say that's a misreading, do you, of that's a mistake as a matter of statutory construction, because the right way of reading section 137 is to look at whether the exchange in question forms part of arrangements, brackets, any arrangements, anything at all that might amount to an arrangement.
Which amount to arrangements, which have as a main purpose the avoidance of tax. That's the important thing.
So you say you can cut it however you like, but if it could be said as a matter of ordinary language that there is an arrangement here of which tax avoidance a primary purpose,
Yes.
that's it.
But also very importantly, that the exchange has to form part of the arrangements.
Yeah, sure.
Yeah. But if those conditions are all satisfied, it doesn't matter that you can identify another set of arrangements that you could...
Or a
you could
bigger
enact.
set.
A bigger set.
On a wider view, you could say,
Yes.
we're taking the arrangements as a whole, I
Yes.
don't think they're tax driven.
Or I don't think I mean, although I think they accepted that a purpose of the arrangement taken as a whole was to avoid tax, they said it wasn't a main purpose because it wasn't sufficiently big in comparison with the commercial purposes of disposing of the shares.
So it was a relative evaluation.
A relative valuation. We say that's not the correct approach. And
So when
indeed-
the tribunal, sorry, just to pick away a
Yes.
little bit more. So when the tribunal talks, like in paragraph 92, it does, and in 93 as well, talks about looking at the arrangements as a whole, which I think is a phrase that comes from one of the earlier cases. They're wrong in that. You don't
Yes.
look at it as a whole. You
Yes.
look at it as a bit.
Well, you identify arrangements which have a main purpose of avoiding tax, and if you can identify such arrangements of which the exchange forms part, then, as we shall see when we look at it, the effect of section 137 is that the reorganisation provisions do not apply.
So, just to be
That's-
clear, you say the finding of fact, which is made, I think, in 92, that the correct identification of the arrangements in question by the application of section 137 to the facts of this case are contained in paragraph 74, Euromoney's submission, as to the 4 elements of the arrangements, was wrong in law.
Yes,
In this case, or you say it could be one of the
Absolutely.
possible arrangements, but it's not the relevant
it's
one,
not the only one,
not the only
it's
one,
not-
and not the relevant.
and it's not one. Well, it's not the one. It's not the one that fails the test, and that's the important thing. And that's
So
the
where do
tribunal
you
seem to
stop?
understand.
I mean, where do you stop in doing this exercise? Do you have to look at every element of the negotiations to see what stages it went through?
No, you look at what the arrangements are to avoid, with the main purpose of avoiding tax. And if you can identify those arrangements will involve a number of steps. If we use the other word that's used there, scheme, you might have more understanding. A tax scheme or tax arrangements involve a number of steps to avoid tax. And that's the arrangement or scheme that you're looking for here. One that has a main purpose of avoiding tax, and of which, importantly, the exchange is part. Now, one of the reasons that the first-tier tribunal decided that this wasn't an appropriate arrangement was because they said that the exchange didn't form part of these arrangements. And that's Mr. Pross's argument, that the whole of the exchange has to form part of it in order for it to form part. I'll come and show you that.
I've misunderstood that. I thought the argument was that the exchange was a part of the arrangements, but the arrangements are a big thing.
Yes, but the argument I think was that they had to be a big thing because otherwise the exchange would not form part of them. And you can see that it's summarised in the first-tier tribunal because they decided it on 2 bases. Yes, if you look at paragraph 79 of the Upper Tribunal decision,
So, which paragraph?
paragraph 79
Of FTT.
of the FTT.
Yeah.
This is Euromoney's argument. The arrangements must be considered as a whole 1371 requires the exchange must not form part of the arrangements. I think they mean it must form part of them for the provision to apply. And logically, as a matter of language, it inevitably follows that the arrangements in question must include the entire exchange. So this was the argument. The reference to the exchange forming part of the arrangements must mean that it is the entire exchange which is within the arrangements, not just part of the exchange. In this respect, Euromoney submitted that whilst you cannot simply equate the arrangements with the exchange, it's wrong to say that the arrangements are something less than the entire exchange. This means that HMRC's description of the arrangements in question in this case are consisting only of the preference shares. The issue of the preference shares, we say under the arrangements, under the exchange, is, as you say, all the preference shares instead of cash coupled with a plan to hold the shares for 12 months must be rejected as far too narrow, taking no account of the other elements of the exchange, such as Euromoney's plans for the ordinary shares to hold those shares with a view to obtaining the financial and strategic benefits in the future, which is the commercial purposes of the exchange from the point of view of Euromoney. So that was the argument that they accepted. That as a matter of construction, you couldn't say that our identified arrangements, that the exchange formed part of them, because it wasn't the entire exchange somehow. Now we simply say that's wrong, that the exchange forms part of the arrangements which we had identified, quite simply because it is step one of the arrangements. The arrangements to avoid tax, the first step is the exchange, which exchanges the shares, target shares, for ordinary shares and the preference shares. And then preference shares are held and then redeemed.
But I thought you accepted that the exchange which is being spoken about is the entire transaction.
The exchange is a single transaction.
No, the entire transaction, in other words.
Well, it is a single transaction, yes. That is, there is only one exchange.
There is one exchange, and that is the exchange for ordinary shares and preference shares.
That is that entire transaction. But if you're asking the question in a tax scheme, does the exchange form part of this scheme or arrangement? We would say the answer is yes. And it doesn't follow from that you then have to examine on this limb all the commercial purposes of the parties in entering into the exchange, which is what the taxpayers say must happen in every case. And I will show you, I hope briefly, the two earlier cases where that was clearly not the approach that has been taken in the past. The examination has never been of the entire exchange and looking at the commercial purposes and weighing them against the tax avoidance. All that's happened in the previous cases, Snell and Call, is that they've looked to see whether there is a scheme or arrangements. In those cases, it was to take loan notes under the exchange and then become non-resident and redeem the loan notes when non-resident. That was the scheme in those cases. And the only question in those cases was whether the taxpayer had the intention at the time of the exchange of going non-resident and redeeming. And in both of those cases, the taxpayer argued before the special commissioners that they didn't have that intention, that they formed that intention later, and that therefore it wasn't a scheme of which the exchange formed part. So that was the issue in those cases. And I shall show you why the decisions in those cases are completely inconsistent with this. Now, my learned friend will say, of course, well, they're just wrong. They didn't. This wasn't argued in these cases, and therefore wrong. But I think it's important you understand that this is not the approach that was taken, has been taken in the past. And we say it's the wrong approach as a matter of construction. Would it be helpful if we just look at the legislation now, because that's really
I am.
what it's all going to turn on. And if we look first at the reorganisation provisions, and section 126, which is on page 8 of the authorities bundle.
126.
Section 126 of the Taxation of Chargeable Gains Act, 1992. this tells you what a reorganisation is. And it also tells you, most importantly for our purposes, what the original shares are and the new holding. And this is all looking from the point of view of the person making the disposal. So we're looking from the point of view of Euromoney in this case. So the original shares are the shares that Euromoney held before the exchange. And the new holding is what it acquires under the exchange, the shares or securities which it acquires.
Sorry, I don't think that's right. It talks about a reorganisation or reduction of a company's share capital. Euromoney didn't reorganise or reduce its share capital.
My Lord,
Euromoney sold an asset.
Yes, my Lord. What you'll find when we get to later on is that an exchange is treated for tax purposes in the same way as a reorganisation. So you have to look at the reorganisation provisions first, and then you'll find in section 135 that it says that it's treated as if it were a reorganisation for these purposes. 1353. The reorganisation provisions that we're just looking at apply with the necessary adaptations as it. We'll come to that, but you do have to look at these. I'm sorry. I should have explained that. We're not looking. This is not a reorganisation.
Right.
It's an exchange. But section 135 applies the reorganisation provisions to exchanges. So, and you have to understand what the original shares and the new holding are. So, the original shares are the shares being disposed of by Euromoney in this case. The new holding is any shares or securities it acquires under what will be an exchange. So, section 127 tells you what the relief is in relation to a reorganisation, which is then applied to the exchange.
Sorry, section 127.
127, which is the next page, page 9.
Yes. Yes.
And this says a reorganisation shall not be treated as involving any disposal of the original shares or any acquisition of the new holding or any part of it. But the original shares as a single asset and the new holding shall be treated as the same asset acquired as the original shares were acquired. So the effect of that, we'll come to see, for an exchange is there isn't any tax on the disposal of the original shares, and the new holding is treated as having been acquired for the same amount as the original shares were acquired. So it's a kind of rollover provision.
It's a fiction.
It's a fiction, yes. Yeah. However, there is a charge where consideration is given other than the new holding. And that's section 128, which is on page 11.
Which is relevant here.
Which is relevant here. And it's section 128, subsection 3, where a reorganisation, a person receives or is deemed to receive any consideration other than the new holding for the disposal of interest in the original shares. And then in particular, I don't think we need to look at that. You should treat it as if the new holding resulted from having for that consideration disposed of an interest in the original shares. And that's why, in this case, if they had taken cash, there would have been a tax charge.
But only on the cash.
On the cash, and it would be around 2 million odd pounds tax. Would have been due if they had simply sold for ordinary shares in cash. And then section 129, I'm not going to look at, but it tells you how you deal with this kind of situation.
Tells you how to what?
It tells you, it goes into the details of how you deal with the part disposal of the new holding. We don't need to look at that. Right. Or section 130 or 131. We can go straight to section 135, I think, which is on page 17. And this begins in subsection 1. This section applies in the following circumstances: where a company, company B, issues shares or debentures to a person in exchange for shares or debentures of another company, company A. And in this case, I think company B would be the purchaser.
I got that as Diamond.
That would be, or Carlisle, yes.
Didn't they form a new company? Which
they formed a new company, yes.
I had that down.
It would be whoever, the purchaser.
And the other one as capital.
Yeah. So, one of the circumstances is case A. That applies in this case, I think. Company B holds, or in consequence of the exchange, will hold more than 25% of the ordinary share capital of company So it's acquiring more than that under this exchange. And then if we go down to subsection 3, where this section applies, sections 127 to 131, which we just looked at, apply with the necessary adaptations as if company A and company B were the same company and the exchange were a reorganisation of its share capital. So that brings in the relief and the rollover. And then there's a definition of ordinary share capital in subsection 4.
Right. So this is a case 1 case, and 1353 applies.
Yes. However, all of that is subject to section 137. Sorry? All right, okay. Subsection 6. Another page. Yes. This section has effect subject to section 137.1. Yes. Okay.
Which is summarised.
Exchange must be bona fide commercial reasons and not part of the tax avoidance scheme. Yes. I think that sums up the present situation.
Well, it focuses on the exchange, doesn't it?
Yes.
Which so does section 1371.
Exactly. It's a summary of section 1371. Yes.
I know, but what
And
I'm
the
saying
question
is that it's
the exchange part of a tax avoidance scheme?
what you're looking at for the purpose of statutory interpretation is whether the exchange is for bona fide commercial reasons and not part of a tax avoidance scheme.
Yes.
Put in simple language, that's what the draftsman was trying
Yes.
to get you
Exactly.
to ask.
And in my submission, if you ask that question rather than the actual question in section 137, the answer would be obvious, that the exchange here is plainly part of a tax avoidance scheme.
Well, the whole thing. I thought
Yes.
the FTT found it wasn't.
No, they didn't. We'll come to what the FTT found, but in my submission, the exchange is one of the steps in this tax avoidance scheme. Just as a sale of shares, if there was a tax avoidance scheme to avoid tax on a sale of shares, the sale of shares would be a part of the tax avoidance scheme, because it would be a step in it. That is, in my submission, that's
I
clearly...
mean, just to be clear, the exchange
Yeah.
that we are talking about is the exchange of shares for ordinary shares as to so much and preference shares as to so much.
Yes.
And in natural language, you say that is part of a tax avoidance scheme.
Because it's the first step in the tax avoidance scheme, the tax avoidance scheme is avoiding tax on that exchange. Tax would arise on that exchange as a single exchange, as we've seen, the way the provisions work. Tax would arise, but for this scheme, so that's the tax that's being avoided. We have a question as to whether this is avoidance of tax, which is this is a respondent's notice point, but I'm assuming for these purposes that this is avoidance.
I mean, I just find that submission quite difficult to understand, and it needs to be unpicked, I think, for me to understand it.
Yeah.
Because I thought that the FTT said it was not a main purpose of the exchange, the complete exchange, to avoid tax. So if you say it is a purpose, then you may be right, but it's for this purpose confusing, isn't it?
I don't think it is. Well, can we look at section 137 and then
Yes.
perhaps we can come back to this.
Mr. Ewart, just before you go there, can I pick up on my Lord's question? The exchange has two components, ordinary shares and preference shares. Yes?
It's got three components really. It's got the shares that are being exchanged on one side, and then it's got the ordinary shares.
Which is going on, all right.
Yeah.
But in terms of what Diamond issues preference shares and ordinary shares.
Yeah.
So that's the side we're looking at. I don't think there's anything wrong with the ordinary shares, is there? You don't take a point on those at all. It's the preference shares that cause the difficulty.
Yes.
So just so I can focus on it, it must be that, as I understand it, you say it is that part of the exchange which comprises preference shares is a tax avoidance scheme. That's really what you're saying, isn't it?
Well, it's a step in the tax avoidance scheme.
Okay.
Because obviously the tax avoidance scheme
But
involves
it is that bit.
a further step, which is redeeming the shares at a time when they qualify for the relief. But I think I might take issue with you talking about being a part of, because it's very difficult to slice up an exchange, because the consideration given by one side is given for all of the consideration given by the other side. So that there isn't any discernible part of the exchange. That's the point I think the Upper Tribunal were making in call. The exchange is a single transaction. And so you can't say that there's any part of it that you can slice off. You can't describe it. You could not say there was part of the exchange. That would make no sense at all in my submission. To talk about part of an exchange.
There's one aspect that gives rise to the revenues concern about tax avoidance. That's a reasonable way of putting it, isn't it? It's
Yes.
one aspect of the overall exchange that gives rise to tax avoidance concerns.
Yes, but that's because it avoids tax that arises on the exchange. And we've seen the way the tax arises is because you're treated as disposing of the original holding for the consideration other than the new holding. So there's no one part. You can't say that certain parts of it are being disposed of for cash. Where you've got an exchange for shares and cash, there isn't any part of the shares that are being disposed of, which are being disposed of for the cash.
The bit I found...
They're all being disposed of for cash and shares.
The bit I find difficulty with is that you say the exchange is one indivisible thing, right? And it is one indivisible thing, namely an exchange of shares in return for ordinary and preference shares. That is indivisible. And then you say tax arises on that exchange.
Oh, would have arisen.
It doesn't.
Would have arisen, but for the scheme.
Well,
because
but you said tax arises on the exchange, and the whole point is it doesn't.
No, my lord, tax would have arisen under the commercial agreement if they hadn't entered into this scheme.
Where does it say that you look at would have? I mean, what it says is that you look at the exchange because it says shall apply to any issue of that company in exchange for blah, and then you ask whether that is that exchange of ordinary shares for ordinary shares plus preference shares, which is an indivisible whole, you say, is effected for bona fide commercial reasons. So presumably you look at the whole. Is the exchange for bona fide commercial reasons? Answer yes. And then you say whether the exchange, that is the exchange of shares, doesn't form part of a scheme of arrangement of which the main purpose is tax avoidance, right? So where do you get to tax arises on the exchange? Because it doesn't.
But my lord, if what you're saying is right, then this provision would never apply, because the actual exchanges that take place, where we're looking at Section 137, don't have any tax. That's the whole point. Without the application of Section 137, there will be no tax.
But why is the...
So you have to decide whether there's tax avoidance by looking at the purposes of the arrangements that they enter into. And you have to look at what would have happened without these arrangements.
Take this a bit slowly, Mr. Yo, because this I think is very important. Just slow that down and tell me what your submission is. That you, if I'm right, you say...
Well, if you're right...
Then there never would be any tax. It would never apply.
It could never apply
would never
because the actual exchange, which actually takes place, will have been designed so that there is no tax. That's the whole point.
So you say you have to look at the counterfactual, should we call it that, of the what would have been, to know whether there's been tax avoidance. That's all part of the analysis.
Yes, and I think when we that may be going towards tax avoidance, and I think actually that the Chancellor in Snell dealt with this point because when he was discussing whether it was tax avoidance, not about the arrangements and the scheme of arrangements, but whether it was tax avoidance, because that question was raised in Snell, and he dealt with it. But the point about a tax avoidance scheme, my lord, if you just step back, is that the scheme will result in no tax being paid. That's why it's tax avoidance.
But the question I'm troubled by...
You have to look at what would have happened without the scheme to decide whether there's avoidance. I mean, otherwise, I can't see how you can ever...
But the question I'm troubled by is that you said that when you consider the scheme or arrangement, tax arises on the exchange. And it seems to me that that puts the cart before the horse. Of course, I understand there is an inquiry as to, once you've identified the scheme or arrangement, whether it is has a main purpose of tax avoidance. But surely you have to work out what the scheme or arrangement is first.
Well, what you have to look at whether there is an arrangement, but arrangement or scheme. But I would submit the way that you would determine that is by focusing on what the purpose of it, looking at if there is some kind of plan, steps executed.
What the purpose of what?
To avoid, with a main purpose of avoiding tax, because that's what we're looking at.
But I mean,
it's a composite.
It sounds to me as if you're saying that you have to look at the purpose of the exchange.
No, I'm not. I'm saying you have to look at the purpose. And clearly that's not, we haven't looked at 1371 yet, but it is looking at the purpose of the scheme. So you have to look at what the purpose of the scheme or arrangements is. You have to look at what the plan of action or whatever, how the things were arranged, and you have to ask, what is the purpose of that? And so in where you've got a tax avoidance scheme with a number of steps designed to avoid tax which would otherwise arise, my lord, if you didn't do it, then that's tax avoidance, and that is a scheme, and the main purpose would be to avoid tax. So there will be a number of steps in a tax avoidance scheme inevitably, and they will result, on the face of it, in no tax arising, if it works. But the crucial thing here is that it relies upon, the scheme will rely upon the exchange reorganisation provisions applied to exchanges. That's what we're focusing on in 137. So this part of the scheme will rely on the exchange provisions. In other words, that there is no tax on the exchange. And then the idea is, rather than deferring the tax to the disposal of the new holding, which is what we would submit as the purpose of these provisions, the scheme has the effect of creating a complete exemption from tax. We'll see. That's what the Chancellor said in Snell. That's what these provisions are about. 137 is about a situation where part of the scheme involves the application of 135.
Sorry, you've just lost me.
No.
I was doing well, and then
Okay,
you just lost me.
well, part of the scheme will
reel
involve
back in a bit.
135, because if you don't have 135, there would be, as I said, there would be a disposal and a tax charge on the exchange. So we start off with, let's take the facts of Mr. Snell's case, which is much simpler in a way. So Mr. Snell had shares, he wanted to dispose of them. If he just sold them for cash, he would have to pay tax on it. So what happened was that they devised an exchange for loan notes to which section 135 applied. So there was no tax on that. But the intention was that he would become non-resident in the future and then redeem the loan notes for cash when he was non-resident. At that stage, there would be no tax on the disposal of the loan notes. And so, by virtue of this scheme or arrangements that had been devised, the deferral of tax under section 135 had become a complete avoidance or exemption from tax. He had achieved selling the shares without tax. And that was why it was said in Snell that was a scheme where the main purpose, in fact, both the commissioners and the court said the only purpose of that scheme was to avoid tax.
But that's because the scheme was identified by reference to the whole transaction and what he arranged to do, and the FTT there found that Mr. Snell had decided in advance to arrange his transaction so that he could pay no tax as you say, so that he could move it from being deferred to exempt. And he had made that arrangement so that the scheme was stage 1, I will sell for loan notes, stage 2, I will leave the country, stage 3, I will redeem the loan notes. And that was the scheme.
Yes.
Now here, the scheme is, as described in paragraph 74 of the FTT, stage 1, I will exchange shares, ordinary shares for ordinary shares plus prefs.
Yep.
Stage 2, I will wait a year and take advantage of the SSE exemption by redeeming my prefs without tax.
Yes.
That is the scheme. And the FTT said here that was not for the main purpose of avoiding tax.
No, it didn't. It said that scheme was for the main purpose of avoiding tax.
No,
That's
they
the whole
said, well, I'll be corrected if I'm wrong.
We can
I
come back to
understood
that.
they
The
said
FTT made two findings.
They said it was the purpose of it, a purpose was to avoid tax, but not a main purpose.
No, the FTT made two findings. One was in relation to the scheme as delineated by the taxpayer, which included the decision to sell the shares in the first place, the target shares, the shares in CDL, commercial decision to sell those shares. It included all of that.
And the ordinary shares in return.
And the ordinary shares in return. Yes, it included the whole lot.
So we're back to the wide view.
The
narrow
wide view, and
aren't we?
it made a finding on that, which was that there wasn't a main purpose, weighing that up.
Yes.
But it also made a finding in relation to the scheme which you just described, which is the scheme which you take, where you take the preference shares as part of the exchange, weight, and then dispose of them. And it made a finding that in that scheme or arrangements it described them as, had a main purpose of avoiding tax.
I understand that, but the point I was putting to you was that the wider scheme did not have a main purpose.
And the issue here is, are they right to say that the only scheme that you test, the only scheme that you apply the provisions to, is the wider scheme as identified, rather than what is called the narrower scheme, but is the scheme we would say was actually designed to avoid tax?
And what you need to persuade me of, Mr. Yurt, is that this section envisages a multiplicity of possible schemes,
Yes.
rather than the FTT identifying one scheme.
Right. Well, shall we look at it then?
Yes.
137, it's on page 20. Subsection 1, subject to subsection 2 below, and section 138, which is the clearance procedure. Neither section 135 nor 136 shall apply to any issue by a company of shares in or debentures of that company in exchange for and respective shares and debentures of another company. So the starting point is the provisions don't apply unless the exchange in question is effected for bona fide commercial reasons, and we'll come back to that. That means that the exchange, the reasons for the exchange were commercial.
The whole
exchange, exactly.
So just to be clear on that, you say that the question is whether the exchange of shares carrying the rights and on the terms prescribed, it's the actual exchange, it's not some other exchange, it's the actual exchange
Yes.
of ordinary shares on the one side for ordinary shares and preference shares carrying the particular rights that the preference shares
Yes.
carry. Whether that exchange was effected for bona fide commercial reasons, and it's accepted, is it in this case that it was?
It was, yes.
Right.
And that was, we might look at that. The Chancellor dealt with that also in Snell as to what that meant.
So issuing the preference shares, carrying the rights of redemption only after a certain time,
Yes.
was effected for bona fide commercial reasons.
No, the exchange was. What the Chancellor
Well, the
decided-
exchange is an exchange of
Yeah.
shares carrying particular rights. It's not any old shares.
Okay, but
It's
what the
these
Chancellor...
shares
Yes.
carrying these rights, which could,
Yes.
for redemption only after a certain period, was effected for bona fide commercial reasons.
Yes. Just as it was held in Snell, that the
Right.
exchange in that case was
And
for
that's-
bona fide commercial reasons.
Right.
Because you don't look at the reason, as the Chancellor said, you don't look at why it was structured in the way it was at this stage. You just look at whether they were selling it to a third party for a proper consideration, etc.
Well, and on these terms as to redemption.
And as yes, but that yes.
Yeah.
But the commercial effect of that, my lord, was simply that they would get the cash in a year's time.
Yeah.
But they
And
were
so
going to,
when they do in fact redeem the shares in a year's time in accordance with the rights attached to the
Yeah.
preference shares, that is simply giving effect to an exchange which has been effected for bona fide
Yeah.
commercial reasons.
yes.
So where's your scheme or arrangement which is effective for tax avoidance?
Well,
What,
well
what else
again,
is
again
there?
if that's right, all these cases would again be, Snell would be wrong because
No,
Snell was
Snell would not be wrong, because in Snell it wasn't just that the shares were redeemed in accordance with their rights. Sorry, that the loan notes were redeemed in accordance with their rights, because the additional factor, as my lord pointed out, was that Mr. Snell had moved abroad and always intended to move abroad. That's the additional factor that makes the scheme or arrangement for tax avoidance and different from the exchange which started it. Isn't that the explanation for Snell?
I think, my lord, you may be looking at the question of whether this is tax avoidance, in fact, rather than tax mitigation.
No, actually, I'm starting as you asked us to do, looking at section 137, and at the moment I've seen that there is an exchange in our current case of shares carrying particular rights, which it is accepted was effective for bona fide commercial reasons. And at the moment I'm not seeing anything else other than the exercise of those rights in accordance with the terms of attaching to the shares. Distinct from Snell, where something else happened. Mr. Snell moved abroad. And at the moment, I find it difficult to understand how you say that an exchange of shares carrying particular rights, which you couldn't redeem for a year, I mean, you said held for a year, they couldn't redeem them.
Yes, but of course that was because they weren't going to redeem them for a year because they wouldn't get the relief. Yeah.
But that term is part of an exchange which you accept was effected for bona fide commercial reasons. I'm struggling to understand, given that acceptance, why you say that there is a scheme or arrangements which involve as one of its main purposes tax avoidance, because I can't match your acceptance that the exchange was for bona fide
Yes.
purposes, but giving effect, just simply carrying it out, apparently becomes tax avoidance. How so? There's nothing else. You accepted earlier on.
Well,
that
that is because
you accepted earlier on that there was nothing more
yes.
constituting the scheme or arrangements in this case than the carrying out of the exchange.
Yes.
So
But that is because when we look at Snell, you will see that the Chancellor drew a distinction between the exchange being bona fide commercial and what he said was it wasn't relevant how you actually carried it out, the exchange, in other words, what the terms were.
But Snell is very. But Snell, I come back. Snell is a very different factual case.
Yeah.
We can just forget what the Chancellor said for a second. In a
Yes.
sense, just look at the facts of Snell. Snell includes a very materially different set of factual circumstances because there was something else other than just simply the exchange on the terms of the exchange, namely the fact that Mr. Snell moved abroad. And that is what enabled the Chancellor to say the scheme or arrangements, wider than just the exchange, constituted tax avoidance, surely.
Well, what the Chancellor in fact said, this is the distinction that we were applying in this case, in Snell, was the question is whether the exchange in question is effective for bona fide commercial reasons. If the answer is in the affirmative, it's irrelevant to consider the reasons why the parties chose to structure their transaction in that way.
Yeah.
So we're not looking at why they chose to structure the exchange in the way they did with the preference shares rather than the cash. We're simply asking, was it a bona fide commercial transaction? Because the structuring question comes in the next limit.
Yes, but try and put it another way, and then I'll shut up and let you carry on. But if a main purpose of what you do is tax avoidance, it's difficult to understand how that could be for bona fide commercial reasons, isn't it?
Well, I'm afraid that the provision, if we read on in the provision, that envisages that you can have an exchange effected for bona fide commercial reasons, which does form part of a scheme of arrangements where the main purpose, i.e. the only main purpose, is avoiding tax. The provision envisages that as happening.
But I suggest it's where in a situation where the scheme or arrangement contains something else than the exchange of shares for bona fide commercial reasons.
Well, yes, I would submit that that's not a distinction that's drawn, and it would be a sensible distinction I would draw, because why does it make any difference to whether something's a scheme to avoid, the main purpose of avoiding tax, that it's been programmed in, if you use, as you say, in some sense from the start. The whole point about cases like Snell was there was a scheme because he had the intention, and it was sufficiently firm intention, of becoming non-resident. So it was the way they looked at it was this was all part of the scheme plan, the arrangements at the beginning.
So
it was crucial that these were arrangements at the beginning.
We got a bit hoist on limb 1.
Yes.
Can you now make your submission?
But I think it is important to look
limb
at limb 1, because limb 1 is dealing with standing back and looking at the transaction and asking, is this a bona fide commercial transaction? The exchange is one, as opposed to, for instance, an exchange which is simply there as part of a tax avoidance scheme. I mean, the classic, your lordships may not be familiar with this case, but Furness and Dawson was the sort of classic case.
I think even we are at Furness and Dawson.
And you remember, in that case, there was an exchange of shares. There was going to be a sale to a purchaser, and they were all sitting around a table, I think, in fact. And what they did was they exchanged shares with a company in Isle of Man called Green Jacket, and then Green Jacket sold the shares to the purchaser. Now there, the exchange with Green Jacket was not a bona fide commercial transaction, and so it would fail the first limb of this test. But in cases like this case, Snell, Call, the exchanges are all actual transactions to third parties, whether you're selling shares for value, proper value. And we would say that's a bona fide commercial transaction. That's what the Chancellor said was a bona fide commercial transaction in Snell. That's the first step. You then move on to the second step, the second limb, where you're asking the question about how it was constructed.
Well, I think that's the difference. Why don't you ask the question of the terms on which the exchange takes place? They must be relevant to the question of whether it's a bona fide commercial. Whether it's effected for bona fide commercial reasons. Well, the terms must be relevant to that question. You can't.
Well, that's not what I would say. It's not certainly our understanding, and not what the Chancellor said in Snell, because we were arguing in Snell that this wasn't a bona fide commercial transaction because it was structured in a way to avoid tax. And he said that's irrelevant to the first question. But of course it becomes relevant when you then look at the second limb, because you then have to ask, was this part of, did it form part of a scheme or arrangements of which the main purpose, or one of them, is avoiding liability to tax? And it's those words we say which show. So you've got to show, the provisions do not apply unless you can show, first of all, it's effective for bona fide commercial purposes. And secondly, it doesn't form part of a scheme or arrangements. And that's why we say, of which the main purpose is avoidance of tax. That's why we say it's not a question of identifying the scheme or arrangements that you're going to apply it to. You have to ask the question, does this form part of a scheme or arrangements of which the main purpose is the avoidance of liability to capital gains tax?
Well, you ask the question whether the exchange, the whole exchange, forms part of a scheme or arrangements of which the main purpose, or one of the main purpose, is tax avoidance, right?
Yes.
And then you say that the words a scheme or arrangements must be construed as meaning any scheme or arrangements.
Yes.
Do you say that?
Well, they mean it doesn't form part of a scheme or arrangement. So does it form part of a scheme or arrangement? If you can identify a scheme or arrangement of which it forms part, of which the main purpose, or one of the main purposes, is avoiding liability to tax, then this provision, you fail this provision.
Any scheme or arrangement. So it is not open.
It can properly be identified.
Well,
as
let
an
me
arrangement.
just ask the question,
Yes.
Mr. Yard.
Any.
It is not a function of the court to identify the scheme or arrangements of which a single scheme or arrangements of which the exchange forms part. It is the function to ask whether there is any scheme or arrangements of which it forms part, the exchange forms part, which has the primary purpose of tax.
Exactly, yes. Exactly.
But Mr. Yu, just again, picking up on my Lord's point, that must mean, mustn't it, that if you have a transaction, a big wide thing, within which there is an element that is built in to, let's say, mitigate or avoid tax, don't want to get into that at the moment, but it's there for tax reasons,
Yeah.
you can always say that on your argument there's a scheme or arrangement which is tax driven, because that's the point of putting that bit in the whole arrangement.
And,
So-
and if
I mean, you can
exactly,
always get
yes.
there. So in fact, you could draft this much more simply, couldn't you? And you could just say something like, so you have your exchange effected for bona fide commercial reasons, and there is no element of the exchange or any associated transaction which is tax driven. You could say that. You wouldn't have to get into schemes or arrangements at all, would you? You'd just say if you've got a feature which is tax driven, that's...
Well, it has to be more than a feature of the exchange. It has to be a scheme that the exchange is
But
part
on
of.
your argument, anything's a scheme, because anything that's got a bit of tax avoidance in it, you can always say that that's a scheme on its own, because you can extract it from
Well, no,
its
because it would have
surroundings
to,
and say that bit was for tax purposes.
There would have to be another. I mean, it wouldn't be enough for there to be a scheme to avoid tax, simply to have the preference shares, because you have to have the redemption tax free as part of the scheme. Otherwise, you're not avoiding
But
tax.
the purpose of the preference
So
shares
you have to
here...
look at a number of
No, that's
steps.
not on your argument. The purpose of the preference shares here, surely, was so that you could sit on them for 12 months and then redeem them. That was the purpose, wasn't it? And it was a tax avoidance purpose.
But there is still a scheme or there are arrangements, scheme or arrangements here. That's what you have to identify.
Well, I see how
And
it's
it's the
drafted.
purpose of
What
those
I'm putting
arrangements.
to you, what I'm putting to you,
Yeah.
is that if you were right in your construction, you could draft this provision much more simply. You wouldn't need to have these words in there. You could take
Well,
you could
I'm not
have
sure.
done it in a
I mean,
different way.
The drafting that your ladyship suggested doesn't sound any more simple than the drafting that's there already. And you then also said tax driven. We have to define that.
Well, I'm not sitting here trying to draft on the hoof. I'm
No,
trying
but
to get
I mean,
at the concept.
once you do start to do that, you realise that this is about. You couldn't. Whether you could have done it more economically is not really the point. I'm not sure you could have. I mean, you can try if you like, but certainly you couldn't obviously do it more simply.
But
And the problem with the taxpayers' argument, can I just turn it round, is what do they say should have been said in order for us to be right? How could it have been drafted to ensure? Now they say any part,
of the exchange.
but that, with great respect, that doesn't make any sense, because there isn't a part to an exchange, and you then have arguments about what's meant by the part of the exchange, and how big a part does it have to be, etc. What does that mean? I mean, the fact
I've
is that
written
the
to
part
my-
of the exchange is not part of this. The scheme actually requires the entire exchange to take place.
I've written
It
to
is part
myself a
of the
note,
scheme.
and I'll just read it out to you. And no part of the exchange has as a main purpose, or one of the main purposes, the avoidance of liability to tax. Would that work?
No part of the exchange. Well, that might, but it would be a different provision, because it would be looking at the purpose of the exchange, and you might say, well, that could apply even if there wasn't any avoidance of tax subsequently, or because you really need to have, you do need to have a scheme or arrangements to avoid tax.
can I ask you why? And the bit I really struggle with, I think your notice of appeal is, if I may say so, commendable, because it raises one point, and it raises the proper meaning of scheme or arrangements, and that's it. That's what this case is about, and we're now there.
Or the word a scheme or arrangements.
A scheme or arrangements.
Yes.
I'm not trying to make it different.
Yes.
Why do you say, when the statute is quite carefully drafted and has two limbs, we all understand what it says and we've read it now countless times, why do you say the court should not be looking to identify the scheme or arrangements of which the exchange forms part before identifying what is its main purpose or one of its main purposes? Why do you say that you look for the tax avoidance element or potential tax avoidance element first and ask whether there is any scheme or arrangements which might have that main purpose? Because the natural reading, to me anyway, the natural reading is, well, you ask whether the exchange, and we know it's a global thing, exchange, it's fine. You ask if the exchange is effective for bona fide commercial reasons, and then you look at that same exchange and say, does that form part of a scheme of, or arrangement? Probably does. You then identify what it is, and then you ask the main purpose question. Now, because if you do it your way, then potentially it always falls foul of this, because there is always, you can always say that there was you don't even need to have the email, because you can always say, well, if you hadn't taken preference shares but you'd taken cash, you would have paid tax. So this must be a scheme or arrangement.
No, that's the... you have to look at what the reason, the purpose of the reasons for it is. For instance, you could have a situation where it was the purchaser who insisted on having preference shares redeemable in a year's time or in 2 years' time as part of the consideration for commercial reasons, because they didn't want to have to pay the money now. So you can't simply look at what the result was and say, well, less tax has been paid than if you'd done it a different way. That's not what we're saying. That's certainly what Brebner says, but that's not what this is about. You do have to identify what the purpose of the scheme or arrangement was. Now, the reason why the email is obviously so important in this case and makes this case very clear one is that it identifies, we know that this wasn't part of the commercial arrangements, because the commercial arrangements had been set, and what was being then proposed was, this is a way of achieving the same result, getting ordinary shares of a certain number and cash. And of course, it was very important to the purchaser that they weren't going to give any more ordinary shares. That was they didn't want to give.
So
any
is
more.
it critical to your argument that it was a change from the commercial arrangement?
Well, no, because in my submission, in this case, it makes it clear what the position was. You might have other cases where it's much more murky and difficult to disentangle whether it was in fact put forward by the purchaser or whether it was put forward by the vendor. And in Call, you may have seen that there was an argument. Mr. and Mrs. Call said, in fact, the purchaser insisted on having loan notes. And the Special Commissioner didn't believe them for obvious reasons when you read that case. But if that had been the case, then of course it would have been very different in Call, because if the purchaser had insisted on it, then there wouldn't have been a scheme.
Could you show us in...
So it's crucial, the purposes of the various steps and the purposes of what was done.
Could you show us, because you say, don't you, that the Chancellor supports this reasoning and this approach. Can you show us why you say that?
Yes. Can I take you to Snell?
Yes.
It's not just that both the Chancellor and the Special Commissioner, in fact, took the same approach. It's behind tab 13. It begins on page 39. And if we look at
we're not bound by Snell,
obviously not. No, I'm quite understand that. I'm not suggesting you are, but I'm simply demonstrating that this this was the approach that's been taken by the courts and
Yes,
tribunals.
I mean, the only
until
thing
now.
I would say by way of comment about these cases is that it's slightly unhealthy to construe cases which don't purport to give guidance as giving as a deed and then saying, well,
Absolutely, yes.
this sentence is properly, it's a dangerous exercise. But
I'm only saying that I'm only looking at this because broadly the Chancellor clearly did approach it in the way that,
Right.
that we are saying,
okay,
rightly or wrongly, and I quite accept it wasn't an issue in the case. No one was arguing, as Mr. Prosser was, that you should look at the entire transaction. But the consequence of this change would be that there would be a completely different argument in all these cases. The only issues in Snell, there were two issues. One was the question about whether it was tax avoidance. That was a kind of matter of construction. I think the Chancellor described it. And the second, but the more important question was whether there was a scheme or arrangement of which the exchange formed part. Because as a matter of fact, Mr. Snell was saying he didn't form the intention to become non-resident until a time after the exchange had taken place. And that was what all of the argument was about, and all the evidence was about. So there's a lot of evidence analysed by the Special Commissioner. And he concluded, Special Commissioner concluded in, sorry, can we just look first of all at paragraph 4, just to see how we identify the scheme or arrangements. Paragraph 4, Mr. Yu identifies the scheme or arrangements as the issue of each of the loan stocks with the purpose of becoming non-resident and remaining while non-resident. So the question was whether that was a scheme which was around at the time of the exchange. And in paragraph 13 on page 50, the Special Commissioner decided that the appellant always had the purpose of becoming non-resident, which became firmer over time.
sorry, which paragraph?
Sorry, 13 on page 50. Right at the bottom of page 50.
Sorry. There's a number of sub-paragraphs.
Page 50.
Oh, sorry.
Special Commissioners.
13 on page 50, yes.
It's just the bottom.
That's the finding of fact.
And then if you turn over to page 52, paragraph 16, which is the conclusion, we find that he had the purpose of becoming non-resident before redeeming the loan notes, and accordingly that one of his main purposes, indeed the only main purpose, of effecting the arrangements was avoiding of capital gains tax dismissal.
So where are you reading?
Sorry, paragraph 16
Yeah,
on
okay,
page
got it.
52.
Got it. Sorry, yeah. Mm-hmm. Yeah.
So there was no question in Snell of weighing up his commercial motivations in carrying out the exchange, which he obviously had, because this was a commercial exchange. He was realising value from his shares to a third party, so it wasn't just a scheme. There was no question of weighing that up against the tax avoidance motives.
Mm-hmm.
They looked at it simply as the scheme was the scheme to avoid tax, issuing the loan notes and redeeming them when non-resident. And that was the approach which the Chancellor took too. Could I just take you just briefly to what he said about bona fide commercial, just which is on page 55. Well, if you begin at paragraph 11, page 55, if you just want to read paragraphs 11 and paragraph 12. And it's particularly where he says, if there is appropriate identity and value commensurate with bona fide commercial reasons, I can see no reason why Parliament should have been concerned with whether the same result might have been achieved by some other legal form or means. This is particularly so when, this is paragraph 12.
Yeah.
When the same subsection uses a non-avoidance test by reference to the scheme or arrangements as a whole.
What does he mean by identity and value?
He means, I think what he simply means is you're selling, who are you selling it to? I mean, in Furness and Dawson, they were selling it to their own company, Green Jacket. So if you're selling it to a third party purchaser, and the value is commercial value, then you would say that's a bona fide commercial transaction.
I mean, but that necessarily involves looking at the actual terms on which the shares are.
No, it involves looking at the value.
Well, which
Yes.
involves looking at the
But what he goes on to say is that we're not concerned with whether you could have achieved it by other means.
I agree you're not.
Otherwise,
I agree you're not interested in how they.
if it was
might
cash,
have-
it wouldn't matter. It's the same.
I agree you're not looking. What he says is you're not interested in whether they could have done it in some different way. But that's he's not saying you don't look at the terms of the actual exchange.
Well, what we were saying in this case, you'll see the argument for the revenue was it wasn't a bona fide commercial transaction because they took loan notes in order to avoid tax. And he said that doesn't matter at that stage of the analysis. It's not concerned with how they did it, it's just concerned with is the exchange bona fide commercial in the sense that the overall value is correct and it's been exchanged to a commercial party, third party.
So looking at the next sentence, this is particularly so when the same subsection introduces a non-avoidance test by reference to the scheme or arrangements as a whole. You say that's loose language and wrong?
Well, what he means by that, we'll go on to see, is that when he looks at the scheme or arrangement, he decides that obviously had only one purpose, which was to avoid tax. So he's looking at the scheme or arrangement
As a whole.
He's not saying what's the purpose of the exchange. The crucial thing is not looking at what the commercial purposes were of the exchange when he comes to the second stage.
No, but your argument involves saying that it is not a test which involves looking at the scheme or arrangements as a whole.
No, I don't. I say you do look at the scheme or arrangements as a whole. You look
Well, you
at the
say you
arrangements
look
and you look
at
at why these arrangements were set up in that way. This is the contrast that he's drawing here. He's saying at the first stage you don't ask why the consideration was in a particular form, because that's what you look at the second stage.
But if you look at the scheme or arrangements as a whole, you're looking at the wider scheme that I put to you earlier, with its 4 stages, as in paragraph 74. And if you look at it as being any scheme or arrangement which is a part of the overall scheme, then you can look at the narrow scheme. Now, he uses the words, looking that the test that is introduced is by reference to the scheme or arrangements as a whole. I think you have to say that's wrong, don't you?
Well, it's not what he meant. If you,
it's not what he meant.
He definitely didn't mean by that.
Right.
You look at the commercial purposes of the exchange as part of this exercise, because that's not what he did when he.
No, you're not. Listen, my lord didn't ask you that question.
No.
He asked you a different question.
Well, but
So
that is
limb two. What do you say to the Chancellor's reference to the scheme or arrangements as a whole? Did he just get that wrong?
No, I think the scheme. He's right. The scheme and arrangements, looking at the scheme as a whole here, the only purpose, as he correctly says in paragraph 29, the only purpose of that was to avoid tax. Looked at as a whole.
In that case.
In that case.
Yes.
Yes.
But it's not this case. Because if you look at the scheme or arrangements as a whole, here, the FTT said it was a purpose but not a main purpose.
Well, I disagree with that.
But you can't disagree with that.
That's not looking at this. It's not looking at the scheme or arrangements. What that is looking at is that does look at the commercial purposes of the exchange, because that's one of the things which they include in the consideration. That's the whole point. They're weighing up the Euromoney's commercial purposes in selling, disposing of these shares for the total consideration that they receive, the value of 85 million.
And taking the ordinary shares.
And taking the ordinary shares, exactly. And taking the ordinary shares, which they hoped would grow in value. So they had all these commercial purposes, and they took account of those and balanced them up against the tax avoidance purposes and said it wasn't the main purpose. Now, that's not what the Chancellor did in this case. He didn't take Mr. Snell's commercial purposes in selling which clearly he had, and he would have had quite substantial commercial purposes. The whole point of the thing was to sell the company and realise value. Obviously, he was doing it in a way to avoid tax on that. but it was not, he wasn't uninterested in any way in the sale. Obviously that was negotiated. The value of the loan note was negotiated. He was getting value out for selling his company.
I get all that, but I mean,
so what they didn't take
saying,
account of in this case was that commercial purpose, and that's a crucial difference between these two cases. But what they did in the present case, the FTT, we'll come to it hopefully, was that they balanced up. They decided that they had to look at all the purposes of the taxpayer in entering into both the exchange and the scheme to avoid tax, and they had to decide on balance, looking at comparing all of those, whether tax was a main purpose, avoiding tax was a main purpose, and that wasn't. I would submit clearly wasn't the approach either of the Special Commissioner or of the Chancellor.
Let's have a look at 29.
So if we look at 29. Perhaps we can look at 27 first. These are the submissions that we made.
Can we go back to 24?
Yeah. Sure. If you want, I think my friend likes you to look at 24. What was being argued was that there was some confusion by the Special Commissioner between purposes.
Yes,
and
but he again talks about the main purposes of the scheme or arrangements.
Yes.
And then 27, did you want?
But there was two, yes, 27 was the what the revenue said. And then 28, the Chancellor.
Well, hang on. 27, you do submit there, I think it is you,
Yeah.
that once the scheme or arrangements have been identified, then it's got to be ascertained whether their main purpose is the avoidance of liability to capital gains tax. So now you're making a different submission.
Well, that was the way we did it in that case. It's a perfectly good, perfectly reasonable way to do it.
Okay, let's look at 29.
But we were all focusing on the same scheme or arrangements in Snell, so there wasn't any. The only question in Snell was whether he actually had the purpose of going non-resident at the time of the exchange, so that it was a scheme which the exchange was part. That was the issue factually in Snell, and the criticism that's being made of the Special Commissioner was that he was muddling up purpose. And what the Chancellor said was that purpose was relevant to two things in this. One was his purpose at the time of the exchange. In other words, did he intend to go non-resident? And secondly, his purpose for the scheme or arrangement, whether it was tax avoidance.
So how do you say 29 helps you?
And 29, well, what the Chancellor says there was it was a scheme in the middle. If that was a scheme or arrangement, then it's obvious that a main purpose was subject to a point of construction, the avoidance of liability to capital gains tax. There could have been no other. So what we're all identifying there was the scheme or arrangements without the commercial considerations of the exchange and why he was selling the shares and how important that was to him. That was the way everyone was looking at it in that case, and that's the way and that's why the Chancellor was able to say, well, if those are the arrangements, then it's obvious the only purpose of those was to avoid tax.
But I mean, 27 makes it clear that you are identifying the scheme or arrangements. In other words, the whole scheme, which was, I will sell these shares in return for loan notes and go abroad and then redeem the loan notes and thereby avoid tax. That was the scheme or arrangement.
Well, the scheme...
There's no salami slicing.
The scheme that was identified was the one that I showed you earlier, that had been identified in paragraph 4 of the Special Commissioner's decision. That was the scheme that was identified.
Well, let's look at it again.
And that was a scheme we were talking about in here.
Yes, and
Because
when we
otherwise you
look-
could-
let's go there.
If
Let's-
that wasn't right, you couldn't possibly say what the Chancellor said.
Well-
There was no other purpose to this than avoiding tax, because there clearly would have been. That's a,
Can I just go back to 4?
yeah.
Mr. Hewitt identifies the scheme or arrangements, to which we shall refer as the arrangements, as the issue of each of the loan stocks with the purpose of becoming non-resident and redeeming them whilst non-resident.
Yeah.
That's the whole thing. Yeah.
Well, it was the issue in the sense that it was the issue under the exchange.
But I mean, there's no, what I'm getting at is, there's nothing in para 4 or para 12 or para 29 that says you salami slice the scheme or arrangements so as to cherry pick something that is
Well,
a tax avoidance purpose. You have to look at the whole scheme or arrangements. But you say no.
but what you don't look at, we would say, and what we didn't look at in Snell, or it wasn't looked at in Gaul, was the commercial reasons or purposes for the exchange. For the exchange taking place in the
Well,
first
you've done
place.
that.
Hmm?
You've done that.
You've done that, exactly, my lord.
Yeah.
But that's exactly what the First Tier Tribunal did in this case. At the second stage, they then said, we will look at the commercial reasons why this exchange took place in the first place. Why were Euromoney selling these shares? What was his interest? What was his commercial reasons? What did they get out of it commercially? 85 million
Can you show us
ordinary
where?
shares. All of that is what this First Tier Tribunal did.
Can we look at the bit of the first tier tribunal that you say is properly wrong?
Yes. Well,
Can we go back to?
there's quite a lot of it, probably.
Well, okay, but
But,
that
Let's go. Can we go to the First Tier Tribunal decision?
yes, please. Which bit does that business of bringing in the commercial considerations in order to identify the scheme or arrangement?
Well, if we start with paragraph 23.
Sorry, are we in the FTT or the UT?
This is the FTT decision,
23.
and sorry, paragraph. We start with paragraphs 73 and 74 on page 93.
Yes.
So that's where you have the revenue submission in 73, what the arrangements are, or what are arrangements that can be identified. In paragraph 70, Euromoney is submitted, that was too narrow. It failed to have regard to the arrangement, namely Euromoney's arm's length disposal of its shareholding in CDL and CNL, Euromoney's receipt of the equity holding, the preference shares and 4.56 million cash, Euromoney's plan to retain its equity holding with a view to obtaining the benefit of a projected increase in value, Euromoney's plan to hold the preference shares. So that's the scheme or arrangements that the taxpayer was putting forward, and that's the one which the FTT said was the arrangements that they had to look at. And then when they considered the question, looking at that, what was the main purpose? What they did was weigh up the various commercial purposes against the tax purpose, and they did this between paragraphs 95 and 107.
Okay, let's look at that.
You say that's an error of law, do you? That there's no permission to bring back in the second limb commercial purposes?
Well, we say the first error is determining that had to be the transaction.
Yeah, understood. But do you say that there's an error if is that the only error, or is
Well, that's the fundamental error, because once
let me finish.
Yes,
I'd understood you to be challenging the way the FTT brought commerciality into the analysis of purpose under Lim 2. Is that right?
What I'm saying is that that cannot be, that they were wrong to treat that as the only transaction that they could apply, they could test, the wider one, including all the commerciality, and that they would have been right.
But if they're right on arrangement, then they're right to take account of commerciality.
If they're right that the only transaction, the arrangements that they can test are those wider arrangements, yes.
Then it's fair
if
enough.
They're right that is the only one that they can, and that they are obliged to do that. And the reasons they thought they were obliged to do it, you can see in paragraphs. I've already shown you paragraph 79. That was the submission, effectively, of law by the taxpayer, that you had to include all of these commercial matters in it, because otherwise the exchange would not be part of the scheme. So that's what they accepted in paragraph 80. And then they went on to deal with a case called Brebner, and they thought that also supported their position. Now, I think because of the importance that they put on it, and because I think, although I think my learned friend accepted, certainly in the Upper Tribunal, that it wasn't perhaps a relevant case, I think it's still important to see why it's not relevant and where they went really badly wrong here. And it's particularly where we say they went badly wrong in paragraph 85, where they said that they thought it was appropriate to rely on the propositions set out by the House of Lords in the circumstances of this appeal.
Could you read 83?
Sorry?
83.
83. I'm not going to read all of 83. You can, my learned friend would like you to read 83.
Well, I think the reason he wants to read it is that you accepted there the proposition that you must have regard to the scheme or arrangement as a whole, rather than considering one element in isolation.
Yeah.
Do you accept that?
Well, I think that's almost a truism, isn't it? Because once you've identified the scheme or arrangement, you have to look at it as a whole. I'm sure that's right. But what they drew from Brebner was that there was a proposition almost of law that you ought to look at the whole of a transaction rather than only part of it. And they sought to apply that to this particular case. And what we say is that Brebner didn't establish any proposition at all. In fact, it was entirely a case on the facts in that case. But I would like to show you Brebner, if I could, because it does draw a contrast between this case, the provisions in this case, and the provisions in Brebner. I wonder if you could just, it's the final.
We've got it in hard copy, did you say, but not in e-copy? That's
No,
or is it the other way around?
the other way around.
So we've got it in, let me just find it then.
I have copies, hard copies here if anyone needs them.
Yes, that'd be helpful because I'm working
Yeah.
on hard, yes please.
It should be in the electronic. It's page 109 of the electronic bundle. So first of all, if we look at this was a case on the transaction securities legislation, and the provision is set out right at the beginning of the headnote. And you can see, in consequence of a transaction securities or the combined effect of two or more such transactions, a person is in a position to obtain or has obtained a tax advantage, then unless he shows that the transaction or transactions were carried out for bona fide commercial reasons, etc., then the section applies to taxing. Now, what happened in this case was that I think it was fishermen. They were trying to buy a company which was involved in the fishing trade, and they had to borrow money in order to do so. So they borrowed money, and then as a subsequent step, a while later, there was a reduction of capital of the company, and they used that money to repay part of the borrowing. So that was what all that happened. Now the problem from the revenue's point of view is that the capital reduction is not taxable. Whereas if they had taken a dividend out of the company, that would have been taxable. So the revenue sought to apply transaction and securities, this legislation, to say that and the question then was whether the transaction or transactions were carried out. And so it was a function of the special commissioner in that case to determine what was the transaction. And the question of fact before the special commissioner was whether there was one transaction of the whole lot together was a single transaction, and that's what they found. And then they applied the legislation and said it wasn't a main object of that single transaction to get a tax advantage. The alternative argument was that there were two transactions. The first stage, borrowing the money and buying the company, and the second stage, the capital reduction. And the second transaction was, the main object of that was to get a tax advantage. Because if you just looked at the capital reduction alone, then you would come to that conclusion. So the revenue had lost on the facts before the special commissioner. And you can see the bottom of the head note. The holding was that the question was one of pure fact, and there was ample evidence in which special commissioners could reach the conclusion they did. So this was a pure Edwards and Bairstow case on the facts of that case. And then we have what Lord, you'll see when we just look at that what he was talking about was in the context of a decision by the special commissioner that there was one transaction. Then it wasn't open, it wasn't right for the revenue to then argue that you should split them up somehow, even though they had been held to be, as a matter of fact, a single transaction. And you can see this if you look at page 117, just by letter F. Lord Pearce says, actually, if we start, just at C, the commissioners rightly approached the transaction from a broad common sense view, and there was ample evidence to justify their findings. And he goes on to say the complete series of events set out in the case table was, in the view of the special commissioners, one consecutive whole. And then he goes on to say, on page 108, it would be quite lacking in reality to draw a line between the first part of the arrangement, namely the purchase of the shares, and the second part, where the overdraft was paid as initially arranged, largely out of the surplus assets of the company. And then he talks about whether it was there's a subjective object that we're looking at. And just about letter E in that page, he says, it would be quite unrealistic and not in accordance with the subsection. By that he means the subsection which says you have to apply to the transaction, to suppose that their object to be ascertained in isolation of each step in the arrangement. Admittedly, an object of carrying out the broad scheme by way of resolution of the tax advantage, but that which had to be ascertained was the object, not the effect of each interrelated transaction in its actual context, not the isolated object of each part regardless of the others. The subsection would be robbed of all practical meaning if one had to isolate one part of carrying out of the arrangement. I think by that he means transaction, because that's actually the statutory, namely the actual resolutions and divorces from the object of the whole arrangement. The method of carrying it out was intended as part of one whole, which was dominated by other considerations. And he then goes on to say on page 119 that he was of the opinion that the special commissioner came to a reasonable conclusion on the evidence before them. They could have reached a contrary conclusion, which would have been equally unassailable had they taken a different view of the evidence. What he's saying is here that they could have decided this was two transactions, but they didn't. They decided it was a single transaction, as a matter of fact. And therefore that's the provision, that's what it applies to. And Lord Upjohn said pretty much the same, although he didn't mention anything on reality.
I mean, Lord Upjohn's is actually the majority decision, isn't it?
He is. I was going to say that, in fact. All the rest agreed strangely and pointedly, which is to follow Lord Upjohn.
Yep.
not with odd payers. Now, the famous passage, which is quoted in almost every tax avoidance case by taxpayers, is the passage on page 121, where Lord Upjohn obviously had a bee in his bonnet about something, and he said, "I would only conclude my speech by saying, when the question of carrying out a genuine commercial transaction, as this was, is reviewed, the fact that there are two ways of carrying it out, one by paying the maximum amount of tax, the other paying no or less tax, it would be quite wrong as a necessary consequence." The word necessary is emphasised, to draw the inference in adopting the later course, one of the objects is for the purpose of avoidance of tax. He goes on to say, no commercial man in his sense is going to carry out a commercial transaction except upon the footing of paying the smallest amount of tax. The question whether in fact one of the main objects was to avoid tax is one for the special commissioners to decide. That I think is an answer to quite an extreme submission put forward by the revenue in that case, which you will find on page 116 at the bottom. It was Mr. Mackay in reply. The final sentence, he says, in deciding whether the object of the transaction was to obtain a tax advantage, one must ask whether that way was chosen to produce the tax advantage. In the present case, that is why the way was chosen. One cannot find that the capitalisation was aimed at anything else. So what he seemed to be arguing was that you had to draw that conclusion as a matter of fact because they did it in that way, and they could have done it another way. And what Lord Upjohn was saying was you can't necessarily draw that conclusion from that. It was all a matter of fact for the commissioners. So we say there is absolutely nothing, there's no principle or set out in Brebner that would be relevant to the present case, and that the first tier tribunal erred in considering that Brebner in any way supported the argument that you had to look at the entire transaction in our case. It was a case about a different provision, a differently structured provision, which did require you to look at what the transaction was. And obviously it was a case on its own facts. It was a case decided on a factual decision. And we say that's quite important because that seems to be an important part of what this first tier tribunal, how they decided this case, because they deal with Brebner from paragraph 81 to paragraph 85. And then they go back to referring to the reality in paragraph 92. Paragraph 92 is where they come to their conclusion. They say, taking consideration the specific circumstances, which I think is just saying on the facts of this appeal, in order to reflect the reality of the position, and we would submit that that's clearly coming from Brebner. That's sorry?
From 84, actually.
Yes. It's coming from, 84. They say there's a clear parallel between the cases and it would be equally lacking in reality to draw a line between the preference shares and the rest of the exchange. We say there's just nothing you can get from Brebner at all. But then they say in accordance with the wording of the statute, and I think that's the reference to the statutory
Where are you taking
argument. I'm looking at paragraph 92 of the FTT decision where they come to their conclusion. So we say where they went wrong. First of all, they went wrong in considering you had to identify the arrangements. And we see that in paragraph 90, just above that. If you read paragraph 90, they appear to be thinking that they have to decide somehow, as a matter of fact, what are the arrangements.
Whereas you say they should have asked whether there were any arrangements which had the main purpose of avoiding tax.
Well, they have concluded that there were arrangements that had the main avoiding tax, because they've concluded that in paragraph 94. Paragraph 94.
But in identifying
Yeah.
arrangements, scheme or arrangements, they should have asked whether there was any scheme or any arrangements that had the main purpose of avoiding tax.
Yes. And having found that there were arrangements that had a main purpose of avoiding tax, the only question they then had to ask was, did the exchange form part of those arrangements?
Well, to which
Because
the answer
that's
is only part of the exchange
Well,
formed those arrangements.
well, that's the question, I suppose. It all comes back, I would submit, to that question. Did the exchange form part of these arrangements that we identified?
Yeah, but you in fact say they should have found it the other way round. You say they should have found that there were a scheme of arrangements. There was a scheme or arrangements for the purposes of avoiding tax, and that is to be assimilated with part of the exchange.
I think what I say is that
Well, you only want us to look at the bit of the exchange that relates to the preference share.
well, the statutory question is,
I know what the statutory question is,
and that's what I'm asking you that should be applied. That you have to ask, having found that there were arrangements, because they have found that,
but the arrangements that have that.
but they didn't think they were the appropriate arrangements or whatever. But having found that there were arrangements which had as their main purpose the avoidance of tax, the only question they should have asked themselves then is, did the exchange form part of those arrangements? And,
I mean, you're putting the cart, I think, before the horse, really. The horse must be, as you submitted, to look at the scheme, to find out what the scheme or arrangements were of which the exchange formed part. And you haven't given an answer yet to Mr. Prosser's point that formed part means, part is a word that's quite clear in the English language. If you have a whole circle, a part cannot be greater than the whole circle.
well, that's looking at circles. But I'm looking at what we're looking at here is a scheme, our arrangements, and asking whether a particular transaction, which is the exchange, forms part of it. That's the question that you're asking, not whether something's in a circle or whatever. But you're asking whether, in the context of this legislation, whether the exchange forms part of the scheme or arrangements. And I would simply submit that.
I didn't understand what you just said. I didn't understand what you just said.
I said
seems
that
to be
you have to ask.
contradictory.
You're asking whether an exchange, which I would say is a legal transaction. It's not a circle or anything like that. It's a legal transaction. And you're looking at arrangements, which are a number of transactions being arranged in a certain way, planned and arranged.
Well, some intentions.
With intention, yes, with intention. And you're asking whether what formed part of that was the exchange. And in my submission, when you have a scheme or arrangement, there will be a number of steps in it. And if one of the steps is carrying out the exchange, then that exchange forms part of these arrangements.
So basically, you say it's not a question of size, it's a question of the elements. And
Exactly.
the elements that you're speaking about in a scheme are different from the elements of the exchange. So when you consider, I'm trying to understand.
Yes, I think that's
when
right.
you consider the exchange, you are looking only at the steps that will be taken to exchange shares. Easy, we know
Yes.
what they are.
That's right.
Ordinary shares for ordinary plus preference.
Yeah.
When you look at the scheme, you are looking at the steps and intentions that have the consequence of avoiding tax. And in this case, the relevant steps or intentions that have the consequence of avoiding tax are only replace cash with preference shares, intend to wait a year, intend to take advantage of SSE when redeeming those preference shares. So you say it's not a question of size, or the greater being the part of the lesser. Yeah. You're looking at something quite different, and the whole exchange is in fact part of the scheme, including intentions to avoid tax.
It's one of the elements.
One of the elements.
It's one of the elements of the scheme.
And what you're comparing apples with pears if you look at size.
Yes. But what you then are asking is, having identified the elements of the scheme, you're asking why were they planned in that way? That's the purpose, was a main purpose of this scheme or arrangements. They're looking at how it was arranged, because that's what scheme is. It's a crafting of things. What was the purpose of that? And the crafting here includes, I would submit, my lord, the terms of the preference shares. Because it was very important that these preference shares, one, didn't give any commercial, they weren't equity in any way, because Carlyle wouldn't accept that. So they had to be essentially something that would turn into cash and could be redeemed by the taxpayer, because obviously that's important as well, because if they just had shares that they have to sell in the market or whatever, then that's not what they wanted. So the way it was crafted was to ensure that it would turn into cash at a time when it would be exempt from tax. So that's all part of that's how the things were arranged. That is the arrangements we would submit. And the question you're asking, the purpose question is what was the purpose of arranging things in that way? That's the statutory question, put another way. Was a main purpose of arranging things in that way to avoid tax? And put that way, we would say the answer is obvious, and the FTT decided it was obvious. Put it that way. If you look at that scheme, look at the scheme arrangements in that way.
Can you then
it clearly
this?
Was to avoid tax.
So I mean, I get all that.
Yeah.
Can you tell me why? So I suppose I can answer my own question. I asked you earlier why you looked at a stage in the negotiations to see whether there had been a scheme whose purpose was to avoid tax. And the reason for that is because the same reason I gave a minute ago. The reason is because the scheme is of a completely different nature to the exchange. The exchange is what is made not taxable by 127 or whichever number it is. The scheme is whatever scheme was entered into and agreed and intended to be performed in order to turn what would have been taxable into something that was not taxable. And it's of a completely different nature, and obviously the exchange, however big, forms part of the scheme, however small,
yes.
To avoid tax.
Yes.
And you say that's what this section is all about.
And exactly.
And you say that Mr. Justice Morritt supports that, but I would put to you that Mr. Justice Morritt was just dealing with something completely different, where, as it turned out, the exchange there did form a part of a bigger whole scheme, and so he didn't really address this question at all.
He did. I quite accept he didn't address this question, partly because it wasn't argued.
No. Okay.
If it had been argued, then he would have to address, well, the special commissioner would have to address the question.
So is this the first case where this precise approach to the difference in contextual quality between exchange and scheme has been argued?
As far as I'm aware, yes.
Yes. And you say, do you? I'm sorry to talk
Yeah.
a lot, but I'm trying to understand. You
Yeah.
say that it's very significant for revenue collection purposes, do you?
It's very important. Yeah, yes, it will be very important for taxpayers and the revenue because this will be a different.
That's why we're here.
Yes, that's why we're here.
Yes.
And it will be very important also that your lordships are clear as to what you're saying, because with greatest respect, we don't think
We
What
do,
the-
we
what
do
the-
try and be clear.
what the first tier
Mr.
tribunal said or the upper tribunal said is particularly clear in another case. They're clear that we lost, but how you would apply it to another case is not too clear. And yes, we would say it's very important. It's the reason why you have to look at the negotiations and why it's totally easy to do in this case is for the reason that one of the reasons I mentioned earlier, that you have to look at why these preference shares are there. That's one of the questions you'd ask, as a matter of fact. In a different case, you might be asking, well, are they there because the purchaser insisted on them? So is it just good luck that the purchaser insisted on them and therefore you were able to dispose of them subsequently? It wasn't part of a scheme or arrangement. So all these kind of questions you have to look at. You have to look at the negotiations and the facts to determine that kind of.
So would you say, you'd say that if, and that the answer to Mr. Prosser's point, which is the sort of one share out of 1,000 point, is that it wouldn't be a main purpose, even if you did that just to avoid a bit of tax, it wouldn't be the main purpose of the scheme.
I think if there I think I have to I would actually positively submit that if there is a tax avoidance scheme within a larger transaction, then that will have the effect.
Doesn't matter how small, you pay all the tax.
You pay all the tax.
10 million in this case.
Yes, but the opposite, of course, might be that however big the tax is, you don't pay the tax, because the opposite position would be, let's suppose you had a transaction that was 10 times the size of this, 100 times the size. This is quite a relatively small transaction in commercial terms. Then the tax might be still the same proportion of the overall transaction. It might be 200 million.
And Willoughby doesn't matter at all, because the nature of the scheme and whether it is tax avoidance is all baked into this statute.
Yes, well, we would follow what the Chancellor said about this. That it is, well, first of all, the way he put it was it didn't matter, but even if you do look at Willoughby and the purpose of Parliament, you come to the same conclusion, because the purpose of Parliament in enacting Section 135 and the reorganisation provisions was to provide for a deferral of tax, not an exemption from tax. So what you're doing here is not acting in accordance with the intention of Parliament in utilising or abusing, some might say, the exchange provisions in order to result in an exemption, complete non-payment of tax.
But what
We
you
would say
It
that is
wasn't
a
exempt. The SSE exemption was always here, wasn't it? It's just they weren't entitled to it until they'd done their preference share thing. There is an exemption here. You can't say that.
No.
Exemption. There is one.
Just as in Snell, non-residents never pay capital gains tax. It's always been the case from time immemorial. But obviously the whole point of a tax avoidance scheme is that there is a provision which gives you an exemption that you're trying to take advantage of. That's what all schemes depend on there being some provision that you can apply. That's what they are.
But the effect is quite
How else should you
radical.
avoid tax?
I mean, the effect is quite radical if you're right. If you build into your transaction any kind of tax, any kind of amendment or detail or little thing that is, of which the main purpose is tax avoidance, like this case really,
Yeah.
where the director wakes up in the middle of the night and thinks, oh gosh, wouldn't it be better to do it that way? We wouldn't pay any tax.
It
That's,
was 8 p.m. in fact.
but that's a really bad thing, because you end up paying all the tax.
Yes.
You're
That-
outside the whole thing.
You might say, well, Parliament has clearly intended that, and for instance, call shows that is an effect, undoubtedly. If you remember call,
Yes, call decides that you pay all the tax.
that even if So Cole, there was Mr. and Mrs. Cole, and the question on appeal was, well, does Mrs. Cole's intention matter? Well, one of the questions. And the Upper Tribunal said, no, it doesn't, because if Mr. Cole had the intention of avoiding tax, then that has the effect on the whole transaction. So there's no doubt about that. And the reason for that, I would submit, is not hard to find, which is to discourage tax avoidance. That's what the provision's about. And it plainly has that effect, that if there is a tax avoidance arrangement, of which the exchange forms part, because it has to be something involving the exchange, then you don't get the relief. And
so you've got
Section
to be careful.
137
I'm just thinking aloud here.
Yeah.
I mean, why? You've got to be careful not to, evidentially, to reduce anything like this to writing. But if you were developing a transaction and you were thinking in a really tax-informed way, on your analysis, you would have to be careful with your commercial negotiations, because if you made a commercial arrangement which had a tax consequence and then changed it to one that didn't, you'd really always be caught, because that change would always be caught. So you'd much better to get to the tax avoiding. Well, hang on. You're much better to get to the tax avoiding conclusion when you start, because then you can't be caught.
I think you'd argue the same thing. You'd say
No,
it doesn't matter.
Exactly. I think that was the point we made to the Upper Tribunal. That we don't rely on the fact that you can see an email from Mr. Flint showing what happened in this case. We don't rely on that as being the only way in which it would you be caught.
So what's the scheme without the email? The scheme is just to redeem the preference shares in a year.
Yeah, it's the issue. It's preference shares that you sit on for a year, and so that you can get the exemption which you wouldn't have been entitled to.
I think what I would say is that if Mr. Flint had this idea a few months earlier, and it had been fed into the commercials thing, so they said, okay, we're going to. They'd asked Carlisle before they finalised the deal, as part of the negotiations, can we take preference shares because we'd like to do this and get SSE, or they might not even tell Carlisle why, but if they said that, the position wouldn't be any different in principle from the position it was, because that would still be, it may be more difficult to prove for the revenue depending on what evidence is available, but that can't be important. The point about this case is the evidence is also sitting there, it's obvious. But it may be difficult to prove, but in principle we would not say it would make any difference.
So put it another way,
it's still a scheme of arrangement to avoid
what is
tax.
exempt, or what is provided for by section 137 is just the deferral of tax for an exchange of shares. If you also have an arrangement whereby you are doing something to avoid tax, so as to not only defer but then take a tax advantage in a year's time that is planned at the time, that will always be a scheme or arrangement whose primary purpose is avoiding tax. And so you've got to be jolly careful to make sure, even if you would have to be jolly careful to make sure it was either part of the commercial arrangements or potentially you'd always be caught.
But the approach that the First Tier Tribunal and the Upper Tribunal have taken still leaves it open in any of the cases that you said for the tribunal to decide, as a matter of fact, that tax was a main purpose. So you're always at risk of that, however you do it. Even if the taxpayer are right, the same risk applies.
But in this case, can we just keep playing with the facts in this case?
You would be in a much better position.
Mr. Ewart.
Yeah.
If Euromoney had had preference shares in capital, which it had swapped for preference shares in diamond, there wouldn't be a tax avoidance issue at all, would it? Because it would always have had the exemption available to it. In fact, it wouldn't have needed to do the preference share thing at all. But let's just say it wanted preference shares. It liked having preference shares.
For a non-tax reason. Well, then there wouldn't be a scheme to. The main purpose would not be to avoid tax. I mean, it would just be, there'd be a commercial
the evil here, the thing they did was to convert their non-preferencey shareholding into preference shares in order to exploit the exemption in a year's time. That's the problem, is it?
Well, what they did was they turned the cash element of the exchange, which would have been taxable immediately, into preference shares, which then could be redeemed subsequently and wouldn't be taxable. That exactly. But I think it's an important point, my lord, going back to what you were saying, that the taxpayer's argument does not, the FTT's decision does not mean that you get off, that you can say you're never going to be caught if you enter into a tax avoidance arrangement as part of an overall scheme. You're always going to be open on their line to having to go to the tribunal and argue about the relative sizes of the various parts and what's a main purpose and what's not. And you could still lose. In this case, if the tribunal had decided it was a main purpose to avoid tax, that would have been an unassailable conclusion on that, as a case in Bremner. So
why have there not been millions of these cases before?
Well, no one, as I said, has argued this point. I mean, if this point is decided in the taxpayer's favour and the legislation remains as it is, I'm sure there will be more cases because people will argue it, but nobody thought it worthwhile, I imagine, previously. I mean, they only argued it in cases where there was a factual dispute as to whether they actually had a scheme from the start. Do you understand?
Like Snell.
Yes. And
but I mean,
it may be that other taxpayers may have been aware.
I mean,
the problem in this case, was that, as I understand, Mr. Flint didn't realise that he was risking the entire tax, as opposed to just the small amount of tax. And it may be the £2 million. So it may be that other taxpayers are more aware of that.
But in any transaction, I mean, preference shares are just delayed cash, and SSE is available always.
No, that's not true.
Well,
preference shares can be. They could have a coupon. They could be an investment.
No, they can be an investment, but I mean, they can also be delayed cash.
They can be, yes.
And they can also have a commercial risk, which I think is one of the points made by somebody in this case, probably Mr. Prosser.
In my submission, that wasn't anything the FTT found, and it's completely unrealistic to suggest.
Well, not in another case.
In another case,
perfectly possible. But what I'm asking is, in any case where there is a cash and a share element of the consideration, which is common enough in corporate transactions, if we were to decide in your favour, the revenue would be able to inquire and say, well, you've taken preference shares, obviously that is tax avoidance, because if you'd taken cash now, you would have paid the tax now, and you're trying to avoid paying the tax ever. And so that it would be open to the revenue to do that. And
well, if the only reason for taking the preference shares, you're saying there was no commercial purpose in preference shares. Yeah. Well, that's right. But even if we lose this case, the revenue can still say the same, because they will say, well, the only question then is whether it's a main purpose and how you decide it. And the revenue could say it was a main purpose of the transaction, even if we're wrong, and you can look at the wide transaction.
And in the normal case, you'd be arguing about whether they wanted to give loan notes because they couldn't afford to pay the cash now, and so.
Well, that might be a factual issue, yes.
Yeah.
Although usually, I mean, the Coles case was unusual because they were clearly not very trustworthy witnesses. But usually, these kind of matters would not be matters of dispute. It usually can be determined by the documents who. But it could be. I agree in principle. It could be an issue of fact. And the revenue might say, we don't believe you, you've got to prove it, the purchaser. But you would normally there'd be email correspondence, but nowadays everything's on email, so you would probably have a lot of email correspondence showing who was asking for what, etc. in the transaction. But you're right, it could be an issue. But I don't, you mustn't get the impression that the result of this case will mean everyone will get off scot-free if they're doing tax scheme. And equally, if you were to decide for the taxpayer, it would just mean there would have to be a lot more factual disputes before the FTT, perhaps, as to what is the main purpose, weighing up all the commercial purposes you had, etc., and how important you thought tax was, and how much time you spent on the tax, which seemed to be Mr. Flint, part of the factual background here. So weighing up all these things.
And you rely on the indefinite article there.
And we say
a scheme or arrangement.
I do, but what I also rely on is the fact, and I think going back to what my Lord Justice Snowden was saying, the provision envisages that you have an exchange which is a bona fide entered into for bona fide commercial reasons.
Yeah.
But then goes on to say that could be part of a scheme or arrangement with the main purpose, not a main purpose, but the main purpose, is the avoidance of tax. And we say that doesn't make much sense that doesn't really make any sense if you would be always looking at the broad commercial purposes of the exchange in answering the second question. Because if you start with a transaction which is must be a bona fide entered into for bona fide commercial reasons to begin with, otherwise you don't get into it. Secondly, if you've got such a transaction, it's very hard to imagine how such a transaction could also have the main purpose, that is the only main purpose of that transaction would be avoiding tax. The two things just don't really...
It's not the same transaction, the point is.
Well, that's what we say. But the taxpayer says it is. Yes.
The exchange is part of a scheme or arrangements.
Yes.
So this section envisages something else being present at the second stage, or something else in the equation.
I agree.
Rather than just the exchange that you considered at the first stage.
I understand. And if you were just saying, well, there is a main purpose of tax avoidance and there's also a main commercial purpose, I would understand that in the context of an exchange which was carried out for bona fide commercial reasons. But it's much harder to see how there could be no main commercial purpose in a transaction that's carried out for bona fide commercial reasons.
No, it's not the same transaction. That's the problem.
Well,
the section envisages an exchange. Look at the exchange at stage one.
I understand that, and you're looking
and you look at the scheme or arrangements of which the exchange just forms part. There must be something else.
Yes.
Stage two.
Yes.
That's what the section envisages.
But the way that you do it, according to taxpayer and according to the tribunals, is you weigh up the commercial purposes of the exchange. And there must be commercial reasons because it's a bona fide commercial, for bona fide commercial reasons.
Correct.
You weigh those against the tax purposes. And what is being said is you could have... On the wider, yeah.
Scheme or arrangement.
And in those circumstances, essentially, I would submit, it's very unlikely and very difficult to imagine how you could come to the conclusion that the main purpose of that overall thing, which includes both the purposes of the exchange, commercial purposes, and the tax purposes, the main purpose, the only main purpose, could be to get a tax.
Sorry, it says the main purpose. Don't add the word only because it's not there.
Well, it's the only main purpose. Sorry, it's either the main purpose, which means the only main purpose, or a main purpose, which means one of a number of.
The main. Main doesn't have to be only. It's main.
It's the only main purpose.
Oh. It doesn't say only. Sorry.
Well, it's the main purpose, or
right, but
it's the main purpose, or one of the main purposes. So
right.
The second part is more than one main purpose, and the first part is one main purpose.
Yes, but the fact you have a main purpose, the main purpose, doesn't mean there aren't other purposes.
No, but there isn't any. There are no other main purposes.
Right.
Yeah, and that's what I'm saying. It's difficult to see how there could be no other main purposes in a transaction where the exchange is for bona fide commercial reasons. That's what
I'm not sure you're adding much to the essential argument, which is that the quality of what you're looking at when you're looking at a scheme is very different from the quality of what you're looking at when you're looking at an exchange.
Yes.
And the first test is testing whether the exchange is for bona fide commercial purposes. The second stage is looking at whether there is a scheme which has its main purpose of avoiding tax.
Yes.
And I mean,
and that's why
see it now.
That's why the main purpose of the scheme could be to avoid tax.
I mean, I see your argument that it would be unlikely that an exchange which was for bona fide commercial purposes would be part of a scheme which was has one of its main purposes as tax avoidance, or the main purpose is tax avoidance. But that's a sort of additional argument.
Yes.
But isn't that precisely what you say here, actually? That this is just that sort of scheme, that you have a genuine commercial purpose for the exchange, limb 1. When you come to limb 2, once you've properly defined what your scheme is, which is the issue of the preference shares, sitting on them for the 12 months, and then the selling them to get SSE, that realistically, the main purpose, possibly even the sole purpose of doing it that way, was to obtain a tax advantage.
And that's because you're looking at different things. The first stage, you're looking at the purpose of the exchange, commercially, whatever. Second stage, you're looking at the purpose of the scheme arrangements and why they were in the form they were. That's what we say at the question. At the second
You say
stage.
size doesn't matter, so it's not.
Well, size doesn't matter because you're not comparing sizes. You're just looking at why have they crafted the scheme in the way that they have.
But it is also the case, you say, that at stage 1 you don't look at the terms. You say it's a less
You don't
refined.
You don't look at the way in which you look at the broad commercial terms. In other words, you're giving your shares for something that's worth, equivalent amounts. That's a factor in deciding whether it's a bona fide commercial transaction. But you don't look at what the detailed terms are, the way in which it's
the
done.
difficulty with that submission that I have at the moment is that if the parties express themselves, as I think they did in this case, in terms of a monetary value, which they then satisfied by issue of ordinaries and prefs, you can sort of see why you could, as Andrew Morris said, compare identity and value. But what if the parties just say, I'll swap you my ordinary shares in this company for some ordinary shares and prefs in your company? It's just a swap, an exchange, and we don't ascribe a value. That's what it would be convenient to do. How do you divorce your question of whether that is an exchange entered into for genuine commercial reasons from the actual terms of the instruments that you are swapping?
Well, I don't. It's not necessary. When the first question is who are the parties to this transaction, because that's what an important first stage. Let's assume they're at arm's length. Right. Then I think that in general one would assume that the consideration they've decided that the consideration is equivalent, and it's not a question of valuing each one.
So is your
that would be a bona fide commercial transaction.
So is your stage 1 really just designed to exclude transactions other than between parties at arm's length?
Pretty much. I mean, it's intended to exclude transactions like, as I say, Fundus and Dawson, transactions where the exchange itself has no commercial purpose. It's just being done as a scheme itself, as a part of the scheme.
So you say that the first stage is actually a very simple one. It's really just, are these commercial people acting at arm's length? And that's about the extent of the inquiry.
And that's what I would submit. That's what the Chancellor said. And yes, that's the first stage.
So
and it just excludes all the complete schemes that are just tax schemes, nothing else.
Yeah, he said actually. You see, that's why I asked you the question earlier. What does identity and value mean in his? I mean, I don't want to get into construing his judgment as a statute, right? But the way you're putting stage 1 really is just identity. Are these people negotiating at arm's length or not?
I mean, I think you would cross-check it by looking at what's being given. I mean, if one thing was obviously worthless and one thing wasn't, then you might then question whether it was a bona fide commercial exchange. But if it's not obvious, then you wouldn't necessarily question it because they're acting at arm's length. I think the reason he put both of them in is because you have to look at them as a cross-check. But essentially, the fundamental point is the identity of the parties is most important. Of course, you might find a transaction between parties who are connected in some way could also be a bona fide commercial exchange, depending on the facts. I mean, if I carry out an exchange with my brother, it could be completely.
But you're very clear the facts that you look at don't include the terms of the instruments you're exchanging, because if you do, then the trouble is.
No, exactly, you don't.
The trouble is, if you accepted that you do, then you would get to the conclusion that actually the exchange, including the terms, would be entered into for genuine commercial reasons, but you then still have to try and find some bit of it, because in this case there's nothing else, which was for tax avoidance purposes, which is the problem.
Well, in this case, but if you were to say, well, we can look at the terms, the Chancellor was wrong, then of course in subsequent cases the focus would be on the bona fide commercial transactions limit, well, perhaps as well as the second limit. So it would make life easier for the revenue in some ways, if you were to say that. But that's not how we've approached it and how the Chancellor approached it. So we haven't decided to try and challenge his decision in this case. It's perfectly reasonable way of looking at the provision. There are two separate limbs that do different things.
Are we moving forward, or are we going over the same old ground?
Well, we may have covered most. I've looked at Bremner, we've looked at Snell. We haven't looked at Call, but I don't know whether it might be worth looking at it for just 2 minutes. There's a very short point on it. And all really I'm showing is that in Call, the decision they made was actually inconsistent with this argument. Can I just tell you that Call is behind tab 14 if you've got a hard copy. It begins on page 63. Coincidentally, one of the special commissioner, Upper Tribunal judges was the special commissioner in Snell, strangely, but so obviously. Now what they say, paragraph 8, we just pick that up. Apart from the issue of whether it's for the appellants or HMRC to say what is the scheme of arrangements, there's little dispute between the parties in the application of Snell. We agree with Mr. Grudinsky that there is no obligation in HMRC to identify the scheme of arrangements. So the appellant to prove that there is no scheme of arrangements. So this is the submission that I've made. And interestingly, the First Tier Tribunal in this case quoted this passage in the decision. Here, in any case, it's obvious that the scheme was the issue of loan notes for the purpose of Mr. Call becoming non-resident and redeeming them while non-resident. Now, there then was a second question which was raised. If you turn back to paragraph 5, you will see the various contentions for the taxpayer. And one of them was number 2. There was no evidence to support the Special Commissioner's conclusion that Mr. Call intended to become non-resident. But then there was also number 4. There was no evidence at the time of the exchange Mrs. Call intended to become non-resident, because both of them had shareholdings in the company and had exchanged them under the same exchange. So there were 2 issues identified. However, the revenue said, well, the issue of Mrs. Call doesn't really arise, because if Mr. Call fails on his argument and that he had the intention, then that will mean that the entire relief will be withdrawn for the entire exchange. And the taxpayer argued against that, but that was what the what the Upper Tribunal decided in paragraph 10, looking at the provisions about reorganisation which are then applied, and noting that there is a single holding of original shares and new holding. They concluded that 137 is all or nothing provision applying to all the shareholders. So what they decided was we only need to look at Mr. Call. If we find against him, that will mean that the entire transaction falls. Now the problem with that, on the argument that's been put in this case, is if the argument in this case is right, they still should have looked at Mrs. Call. In fact, they had to look at Mr. Call, not just his purposes in taking the loan notes and going non-resident, but his commercial purposes in effecting the exchange in the first place. Because again, this was an actual exchange, actual realisation of value of the company. So what they would have had to do is to look not just at Mr. Call's intentions, commercial and tax, but also Mrs. Call's, because she was part of the exchange. But they didn't do that. That's because they didn't take the approach in this case, they took the approach that you simply look at the scheme of arrangements and look at the purpose of that, and you don't weigh up the commercial purposes of the parties in any way. Now, again, that was because it wasn't argued in that case, no doubt, but it would have had that consequence in my submission, that they would have had to have looked at both Mr. and Mrs. Call, and they have to have looked at all their purposes, not just looked at the purposes of Mr. Call in his scheme of arrangements for avoiding tax. And we would say that they applied the correct approach in that case. There was no question that once you'd identified the scheme of arrangement and it was decided that he did have the intention at the time of the exchange of becoming non-resident, that was the end of the issue.
Well, not only for him, but every other taxpayer involved in the exchange.
Yes.
And so they all get stung for the maximum amount just because one of their number may secretly have had the intention of
Well,
sure.
It wasn't secret, but yes, he
Okay,
had a plan. Yes.
But so you have a whole bunch of shareholders who are all exchanging their shares, as shareholders do, as part of a transaction.
Yeah.
And unbeknownst to most of them, one of their number, perhaps a significant shareholder, actually has an intention at the time to go abroad in the way that Mr. Snell did, for example, or Mr. Cole here. That means all of them lose any possibility of
You
any
would
tax
first have to
advantages.
look at why. I mean, you're assuming that they were taking, for instance, loan notes
Yeah, but
in response.
It wouldn't be part of the scheme or arrangement because it was a secret intention that wasn't shared with the other participants in the scheme.
And it might not be, because in this case it was.
But you'd say it would be part of the scheme or arrangement, wouldn't you? Because it's part of his scheme or arrangement.
If his scheme of arrangement, including, so why did he take the loan notes? Is the question.
Yeah.
Why were loan notes? Sorry, why were loan notes given under the exchange? And if that was so that someone could go non-resident,
Like
then
he wanted loan
that could
notes.
be.
He's the dominant shareholder.
Yeah.
He says, "I want loan notes, please." Thinking to himself, or quite clearly,
Yeah.
thinking, planning to go abroad so that when they are payable, he doesn't suffer tax. The other shareholders have no such intention at all. They just think whatever Mr. Big is doing,
That's fine with us.
he knows what to do. We trust him.
Yes.
We'll take loan notes as well then.
That's always potentially going to be the answer, whichever way you decide this case.
Right.
Because it just may be slightly more difficult in some cases to establish if you decide it for the taxpayer.
Well,
but in all cases, even if you decide it in favour of the taxpayer, there will be that situation, potentially, theoretical situation
Well, it
could arise.
depends on how you define scheme or arrangements in those circumstances. Because if you say it's the whole, including all the shareholders, you may come to the conclusion.
You may.
Because a number of the shareholders, perhaps most of the shareholders by number, had no such intention.
Yes.
That it wasn't the fact that one of them did, perhaps holding a larger proportion, it didn't constitute
But it could
the main or part of the main. Whereas if you just focus on him, you will always answer the question, well, of course, that was his main purpose, and that's it.
Yes. But in the first case, all right, some cases you may succeed, on cases you may fail. Some cases it may be still a main purpose of the exchange, of the scheme, if you're looking at it broadly, to avoid tax. It may depend on the values.
You say the revenue can salami slice up the transaction as a whole and focus simply on the scheme or arrangements of one of its participants.
Of which if the exchange forms part of it, which it would, I think, in the example you're giving.
Well, the exchange, no, it wouldn't, you see, because the exchange is the exchange composite transaction, unitary, of all of the shares. How can that form part of Mr. Big's individual scheme?
Well, if that's right, then that would mean that you could never be caught if he was only part of the transaction.
Right, we're going to come back to this at 2
Which-
o'clock,
yeah.
Mr. Hewitt. I take it you're not worried about the time, Mr. Prosser?
It all depends, I suppose, but so far I'm not worried.
Good. 2 o'clock.